Good morning, everyone, and thank you for joining us today for our annual Employment Law Seminar. And we are so pleased to welcome so many of you to our event today and to see some of our clients with us as well. So we have a packed agenda covering crucial updates in employment law. So let me share our plan for you for the next couple of hours. So we're going to start by taking you through some housekeeping formalities just to help with the smooth running of today and to help you get the most out of the seminar as well. We'll then drive in to look at the highly anticipated Employment Rights Bill, exploring its key provisions. Following that, we'll shift our focus to the practical implications of these reforms and look at how employers can prepare for and adapt to these changes, ensuring compliance and minimising potential disruption. And after the Employment Rights Bill, we're going to discuss the introduction of neonatal care leave. This is a significant development, providing much needed support for parents of premature or sick babies. So we'll go into that as well. We'll then move on to a forthcoming piece of legislation known as Martin's Law, which is a development in health and safety. And then we'll turn our attention to a range of other important legal developments expected this year. And then finally, before we open up the floor to questions, we'll review some of the key recent employment tribunals. These cases provide valuable insights into how employment law is being interpreted in practice. So we'll discuss the key takeaways and how they may impact your business. And then we'll finish with our live Q&A session. So please feel free to ask any questions you have about the topics we've covered, and then I'll share some closing slides with further resources and contact information. So let's start by taking you through some housekeeping formalities. As I said, it will help with the smooth running of our seminar and to help you get the most out of it as well. So we'll start by introducing ourselves. I'm Victoria Templeton, the HR Knowledge Manager here at HR Solutions. Having worked in the profession for over 25 years in various sectors and roles, my role at HR Solutions is really focused on the HR-related knowledge and responsible for the content that is then used for the delivery of all of our services. So I'm going to be taking you through some of the topics today, and will be taking part in the live Q&A as well. And I'm joined by Sue Watson. Sue is our Operations Director, having worked in the profession in a senior capacity for many years, and with the last 20 years working for HR Solutions. So Sue will be able to share her insights on today's topics from an employer's perspective, and will be on the panel at the end taking your questions. We're also delighted to have two guest speakers with us today. We have Sheena Harris, who is a senior HR consultant. Sheena brings a wealth of knowledge and experience from the work that she does supporting our clients across many sectors and of all sizes as well. So Sheena will be taking you through the implications of the Employment Rights Bill and what they may have for employers, and will share with you her advice on what to do to prepare for the coming months. We'd also like to welcome Lauren Gibson. So Lauren is our health and safety consultant, who again brings a wealth of knowledge and experience in the area of health and safety. Lauren will be taking us through developments in a key area of public safety known as Martin's Law. And we are also supported by Rebecca Johnson, our marketing manager, who will help with any technical issues that may arise. Hopefully, though, we won't have any issues from that perspective. So we do want to get everybody involved and to make this seminar as engaging as possible. And we've got many ways in which we can do that. So first of all, when you see this slide, and for those of you that are familiar with our live virtual events, we often run polls. We find using polls a really good way of engaging with everyone. So when you see this slide, it means we want to hear what you think, and we'll be opening up the polls. The use of polls not only help us in steering the event, but they also allow the sharing of best practice and to share how organisations are managing the topic that's being discussed. So actually, we find it can be really reassuring for everybody on our event to know that they're not on their own. Other organisations perhaps feeling the same, or other organisations are taking the same similar steps. So both Sue and I will also share our thoughts on the polls as they come through. Another way in which we want to engage with you and make this interactive is to run quick pulse checks. So these really are about sense checking as we progress about how everyone is feeling on the topic of the discussion. Quite often these can help give those reassurances, like I said a moment ago, because you can see how others may be feeling too. So when you see this slide, just take those few seconds to share your thoughts. These interactions are for you. They won't necessarily need any commentary or follow-up from Sue or I, but they are a good way just to check in with everyone to see how everyone's doing and how they're feeling about the topic we're talking about. And finally, you can ask us your questions on anything we'll have discussed today. So we'll be taking these live. So as we take you through the seminar, please do raise any questions you have, and you can do that through your GoToWebinar panel. If we can't get through all of your questions, don't worry, we still want to respond to everyone, and we'll do that by following up on today's event with a FAQ document in which we'll respond to all the questions. So whether there's some that we can answer today and then some that we follow up in writing, we will respond to you all. So to submit your questions to us, you will see now on the screen what your GoTo panel looks like. So please type in your questions as we go through the seminar, and then, as I said, we'll aim to answer as many as we can at the end. And if we don't have time, then, as I said, we're going to be publishing the FAQ document. Now, another way we want to engage with you and to help you with sharing of information, that we have various documents and handouts. So we're going to flag throughout where there's a relevant handout to accompany the information that's being discussed on a particular slide. So when you see this handout indicator, please check out the handouts in your GoToWebinar panel, and that will be something for you to take away after the event. We'll also be sending a copy of the slides to everybody after today, and then along with the slides, we'll also share a link to the recording. So if you want to recap on anything that we'll have gone through, or even if you want to share the link with other managers in your organisation, then please do so. So this slide reflects that we're going to be running some polls, and actually before we get going, we would like to get to know you a little bit better and just to understand the kind of organisations that you're working in. As I said, this will help with our seminar. So if I can ask Sue to open the first poll.
There we go.
Thank you. And this is about understanding the size of the organisation that you work in. And we'll give it a few moments.
Okay, I will close that poll and share those results.
Okay, so most are between 50 and 249. Yeah.
Okay.
Got a few mic vote. Brilliant.
And then I will. Next one is the sector. Okay, I will close and share those. There we go.
Probably private, but we've got people covering all areas, haven't we? Charity as well. Okay, thank you. And then there is a couple more.
Yeah. So this one's who looks after HR management in your business. Okay, I will close and share that one. So we have in-house HR team and or an in-house HR manager. So yeah, it's the majority. Okay, and then I think we have one more.
One more, that's right.
Yeah, and this is your business unionised or currently going through the process?
Yeah, which we could see more of in the coming months.
Absolutely. Okay, I will close that poll and share that one. And
so predominantly, yeah, not unionised.
But we do have people going through the recognition process as well.
Oh,
yes.
interesting. Hope it's going okay. So thank you for that, Sue. So I'm going to now start with the first section of the session, and that's going to be covering the Employment Rights Bill. And it's a piece of legislation, when it's passed, that's designed to modernise and strengthen worker rights. So from what I'll be telling you, you'll hopefully see that actually it's the biggest shake-up of employment law in decades. The reforms that I'll be going through will ultimately be incorporated into the Employment Rights Act of 1996. Now, there is the potential for some of the reforms to come into force this year, but the majority, according to the government, will not come into force before 2026. And we even know there's a couple that won't come in before autumn 2026. And that's because many of them will require secondary legislation in order to bring them into force, further regulations, because regulations give the greater detail into how it should be practiced and operated. We'll also need to have codes of practices drafted up and various government guidance documents around the reforms. So that's why a majority of them won't come into force before next year. In terms of the developments in this bill, they're happening quite quickly at the moment. We're seeing lots of in the news at the moment. So at the start of this week, the Business and Trade Committee published their report, Make Work Pay Employment Rights Bill. Now, this is a comprehensive analysis of the proposed reforms, and it's a report that follows the recent public consultation in which they gathered both oral and written evidence from employers, for which HR Solutions participated in, along with many other employers, professional bodies and trade unions. So what we've got here, there's a handout available to you, and this handout for you provides an overview of the government's recommendations for what happens next for some of the reforms. So please do check this out, as it provides some useful information about what we'll potentially be seeing next. And of course, we'll be touching on these developments as we go through the slides. So in terms of where the bill is at in the parliamentary process, you'll see the current status here on the screen. So I've put the date at the top right of the slide, as you can see, just so you know it's as of today's date. And we are at the third reading stage in the House of Commons, so it needs to then be handed over to the House of Lords for a similar process involving debates and amendments. But the bill has potential to be completed by as early as this spring, summer of this year. So it's really important that employers start to think about what is coming up in the future and be prepared, particularly for those that have the potential to come into force this year. So in terms of the bill itself, it's making reforms really to every aspect of the entire employment life cycle. So it will impact contracts of employment and working arrangements, how you pay, reward your employees. It'll impact on family leave entitlements, industrial relations. So I know majority are not from a unionised environment, but we could see increased recognition requests. And it also looks at reforming the way in which the legislation can be enforced. So we're going to take each of these sections one at a time to just let you know what those reforms are. But we do have breaking news because as of yesterday, late afternoon, we had further publications from the government. So they are continuing to happen all the time. So what I'm going to do is I'll flag in the following slides where we've had some news on the reforms. But you'll probably be hearing a lot in the news, but I'll be incorporating those in the slides. So first of all, I'm going to look at contracts and working arrangements. And first of all, it's looking at changing the current rules around flexible working. And that's going to be by requiring a flexible working refusal to be reasonable. So currently the legal test is that the refusal of a request has to meet one of the statutory decline reasons. Now that will still be the case, but what this bill is proposing is to actually broaden the test and will require the employer to be reasonable in their decision making, as well as obviously meeting that decline reason. So it just probably broadens the scope in which employees can raise claims. For those of you who use zero-hour contracts, this area is going to get a huge reform. It's being proposed as a way of banning exploitative zero-hour contracts, and for a while we've not really understood what that means. But as we get more updates come through, what it is meaning is that the bill is proposing to ensure that workers have the right to at least a guaranteed number of hours in their contract, and that these hours are to be determined by a particular reference period that looks back at previous hours worked. So also in the same area, the bill is proposing to require employers to give reasonable notice of shifts, the cancellation of shifts and payment for cancelled shifts at short notice. So the breaking news that's come out in the last 24 hours is around the reforms in this area. So we know that the government, the committee that submitted their report are recommending to the government to define how many weeks the initial and subsequent reference periods should be for determining what number of hours go in that contract. They are also recommending that the government provide clarity on what is meant by reasonable notice of a shift that the employer requires or requests the worker to work. They're also asking the government to provide definitions of what is meant by moved or short notice in respect of cancelled or curtailed shifts. And what we heard yesterday is that agency workers will be included in this right. And it means the responsibility for providing the agency worker with reasonable notice of shifts will be on both the employment agency and the end hirer, with the tribunal able to apportion liability based on the responsibility of each party in a given case. The news yesterday also talked about responsibility to pay any short notice cancellation or curtailment payments will be on the employment agency, but they will be allowed to recoup this from the hirer where they have arrangements with the hirer covering this. So this is a big area of reform. It sounds a little bit complicated. We do need those further regulations to set out the detail, but these are the principles of where we're seeing it evolve. When it comes to sexual harassment in the workplace, well, we've already seen changes last October, which placed a new legal duty on employees to take reasonable steps to prevent sexual harassment. But under this bill, the proposal is again to widen the scope so that it now becomes a legal duty to take all reasonable steps, not just reasonable, but all. Also in this area, the bill is proposing to introduce legal duties in respect of third-party harassment protections and to widen the scope of existing whistleblowing laws by adding a new public disclosure category of sexual harassment allegations. Moving on, we're going to see a ban on fire and rehire. That is effectively a fire and rehire is when you're trying to vary somebody's terms and conditions, you end up dismissing them, but then you offer re-engagement and rehire them on new contractual terms that are quite often lesser terms. So the reform is going to make this unfair, and where there's a dismissal connected to an employee failing to agree to a variation of contract. We are expecting to see changes to redundancy. So the reform proposes to remove the Act 1 establishment requirement for collective consultation. So currently under legislation, an employer has that legal obligation to inform and collectively consult with its employees when it proposes to dismiss for redundancy 20 or more at one establishment in any 90-day period. And we've seen that definition of what is one establishment be questioned through various courts. And what the Employment Rights Bill is proposing is to remove references to one establishment so that the requirements to consult collectively and to notify the Secretary of State applies where an employer is proposing to make 20 or more employees across its business, not each location. And that's going to be significant for, particularly for those that have many different sites in your operation. But again, in the breaking news that came through yesterday on the bill, there was a hint that the government may row back slightly on this initial proposal. We're just working our way through the response, so we'll keep you posted. So do please sign up to our email alerts to keep getting the updates. Also in the news, the government have confirmed that the cap on protective awards in collective redundancy situations is going to be increased from 90 days to 180 days to encourage that employer compliance. So if there's any of you on today's seminar that work in the shipping industry, then ship operators will be required to notify the Secretary of State for collective redundancies affecting a ship crew. This is on the back of the P&O mass redundancies that happened a few years back, where essentially they failed to follow any fair procedures when they were dismissing about 800 employees. And then finally in this area, they are looking at changing or introducing, quality action plans for those organisations. So it will affect some of you on this seminar, those of you that employ more than 250 employees. So this slide alone, I think it's fair to say that it is significant, even just looking at the contracts and working arrangements. But if we now look at pay and benefits, first of all, one of the massive reforms is around statutory sick pay. First of all, they're going to remove the waiting days. So if somebody is off today sick and it is only one day, they'll be entitled to statutory sick pay if they meet the usual eligibility criteria. So they're removing these waiting days, and they're also going to remove the lower earnings limit that's used to calculate if somebody is entitled to pay, but they're going to replace it with a percentage replacement rate. And one of the updates yesterday is that that is going to be set at 80%. We also know that the national minimum wage is going to be reformed, and they're going to remove eventually the age bands. We're already starting to see changes where we transition to just having one age band, because they've been making larger increases in the rates in certain age bands than others. And they're also going to task the Low Pay Commission to factor in the cost of living each year when it recommends rates to government. So that actually already happened last October, November. So that piece has already taken place. For those of you that operate in hospitality where tips are significant, then employers will be required to consult with the workforce when reviewing their tipping policy about how those tips are allocated. So we had law that came in last year, and whilst it didn't specifically make it a legal requirement, it only recommended best practice. So it's tidying up around this area, and it will become a requirement legally to consult when you're changing your policy. The reforms also include requiring the tipping policy to be reviewed no later than 3 years from the previous review, and to feedback from the consultation process to all workers by publishing anonymously that feedback that's come through from the process. And finally, in this area, we're going to see reforms around equality. So the rules on gender pay gap reporting will be extended, and that will be to allow employers to disclose the employment agencies that supply them with workers. We'll see quite significant changes around family leave. So first of all, paternity leave will become a day one right, and employees currently they require the 26-week service, but with other as with other forms of family leave, there won't need to be that qualifying service, but there will be to continue remaining to continue to receive the pay. But to be able to take the leave, it'll become a day one right. The employee will also have the ability to take paternity leave after a period of shared parental leave. Now, currently that's not allowed under the legislation, so they're extending it in that perspective. We're also going to see changes to parental leave. So that is currently where the employee needs to have 1 year service in order to be able to qualify. They're going to remove that and again make it a day one right. We're also going to see the current law on parental bereavement leave amended so that it is broadened and no longer applies to just parents. And so it's about giving all employees the ability to have a statutory entitlement to take bereavement leave. From what we've been reading, it's understood that the leave remains at 2 weeks in the case where there's been the loss of a child. And we're waiting for further details around the duration of statutory leave for all other relationships. And that's why we need the regulations. But it could be 1 week, we don't know. And I suspect because a lot of employers will have compassionate policies already in place, this just means it has to be it's a legal requirement. And then finally, it's going to become unlawful to dismiss an employee during pregnancy or on return from family leave, whichever form of statutory family leave. Pretty much like the current position that we have with redundancies and returning to work that we saw last year. So there are going to be lots of reforms to industrial relations, and I appreciate that most of you on this seminar aren't working in a unionised environment. But as I hinted on a few moments ago, I think we could see recognition requests increasing. But let me just take you through these. So first of all, they're going to reintroduce the school support staff negotiating body and launch a new adult social care negotiating body as well. It's going to give workers a right to have a statement setting out their trade union rights. They want to repeal most of the measures from the Trade Union Act of 2016. They want to introduce a new right for trade unions to access non-unionised workplaces. And we know from yesterday's announcement that the bill will be amended to allow access arrangements to include virtual access as well, either solely or alongside physical access. The bill is looking to reform the statutory recognition process, which includes, as announced yesterday, providing the Central Arbitration Committee, the CAC, with a framework for fines to be issued for non-compliance with the right of access. They're going to introduce a right to pay time off for trade union equality representatives. And also announced yesterday afternoon is that the current mandate for industrial action being valid for 6 months before it expires, that's going to be extended to 12 months. The bill is also aimed at tightening up the current law against maintaining blacklists of trade union members and activists. And they're reforming the way in which ballots are managed. So they're going to introduce electronic balloting for industrial action. And in the news yesterday, it was announced that there will be a requirement for a 10-day notice period for industrial action. Currently, it's 7 days notice. Also in the announcement yesterday, it was confirmed the current proposal to repeal the 50% industrial action ballot turnout threshold will not be enacted immediately, but will require separate regulations with the aim of dovetailing this change with the introduction of e-balloting. In terms of how political funds will be managed, unions will no longer need to ballot members every 10 years regarding whether they wish to maintain a political fund. This is something that came out in the news yesterday. Instead, it's going to be replaced with a requirement that unions give members notice of their right to opt out of the political fund every 10 years. To address the issue of mass recruitment into the bargaining unit to thwart trade union recognition, the maximum number in the bargaining unit will be set at the date when the Central Arbitration Committee receives the application for recognition. And we are going to see the bill make it unlawful to suffer detriment on grounds of industrial action, as there's a conflict in existing legislation in two different pieces of legislation. So they're going to just tighten that up. and provide protection of workers on contracts that are outsourced from the public sector, so that we don't have that two-tier workplace. So I think there's going to be a lot of noise around trade unions. There's obviously, they're calling on for more transparency, which is why I think perhaps we could see greater increase requests for recognition within workplaces. And this is the slide. It kind of makes me laugh because it's got the least amount of information on, but probably is the biggest when it comes to reforms. And that's all about the enforcement. And it is significant because the unfair dismissal rule, where you have to have 2 years qualifying service to be able to claim an unfair dismissal, they're scrapping it. So essentially, everybody from day one of employment will have a legal right to claim unfair dismissal. We don't know all the detail of how it operates in practice because we need that second legislation and the regulations to guide us. But what we do know is that there'll be the introduction of a new statutory probation period. And there's been a recent consultation on these areas to gauge what kind of length of probation period. And I think the government's position is thinking more of a 9-month probation period, but who knows whether it's 9 months, 6 months. We need to wait and see. So that is going to be significant. And then we're also going to see an increase in tribunal time limits. So where at the moment employees have to submit a claim within 3 months, that's going to be extended to 6 months. And alongside that, to help deter employers from applying weak or poor processes and policies, they're introducing a new enforcement body called the Fair Work Agency, and they will be given the statutory powers to be able to enforce the legislation, and will have various mechanisms available to them to get that enforcement. So I'm going to run a quick pulse. Really, it's just to sort of sense check, and so you can see how everyone's feeling on this seminar. How prepared is your business for the reforms?
Okay, I will close that now.
Thank you. We'll just share and then we'll move the slides on. So can everybody see?
There you go.
Yeah, perfect. So that just gives you an idea of how everybody else is feeling. So let's move on to what could we see this year. So I mentioned earlier that majority of reforms won't come in until at least 2026, with some being autumn 2026, but there could be some this year, and that's because we don't need the second legislation. So what this slide is essentially sharing with you is taking each of those different aspects of the employment life cycle, those items that don't need the second legislation, they don't need guidance, codes of practices, it is good to go as soon as the bill is passed. Obviously, there are some huge ones there. So, for example, the ban on fire and rehire, removing the one establishment, the removal of the SSP waiting days, that's going to be really, really significant. What else have we got? The time limits increasing from 3 months to 6 months for tribunal claims. So these are just potential. We don't know if they will or at what point. So when a bill gets passed and becomes a piece of law, it can instruct a part of it to come into force the next day. It can instruct other sections of it to come into force 3 months down the line, or it could say that we're going to introduce this 1 year on from the bill being passed. So it's all potential, but we should still be taking steps to prepare for the changes ahead. So we're going to now run, we've just got one poll here, and this is really just to think, really, what kind of support do you think would be most helpful for you and your business in preparing for the reforms?
just let that run for a few more seconds. I think because there's so many of us on the call, it's taking it a while just to catch up.
Is it?
Okay, I will close that and share those results.
Okay, so interesting. Yeah, I think it's going to require a bit of everything, isn't it? I think because it's so significant. So, Sue, from your perspective, from an employee's perspective, do you have a view on the reforms in terms of the impact, or what reassurance can you give to everyone on the seminar?
I think you know, clearly it's excuse me, clearly all the legislation can't be introduced in one go. Hopefully the government will understand that we need quite a bit of time to prepare for some of them. So and we do need, for some of the, as you pointed out, you know, already, some of them will need more regulations being passed, and we're waiting for codes of practice to give us the detail behind actually how we're going to implement these. So we can prepare as much as we can, but we'll still be waiting for the real detail, which will affect, you know, ultimately what we need to include in our policies and in the guidance. So, but we do know that while some could come in this year because they don't need any more legislation to bring them in, we have got the majority coming through next year. So, you know, and some of them towards the end of the year next year. So we have got some time to prepare. So we are, as you are doing, you know, keeping a watching brief on all the changes. And as soon as we get anything concrete and detail, we will be letting everybody know, and we'll be updating everything we've prepared so far so that we can share that with you. So yeah,
we are monitoring it daily, aren't we?
we
Even
are.
yesterday afternoon, the developments coming through, and I think Sheena will shortly be giving you her guidance on preparing anyway, so we'll find out a little bit more about that shortly. So if I get back to the seminar, and really this section of the seminar is really to talk about everything that I've gone through here in terms of the reforms, how they'll impact on employers rather. So we're going to shift our focus on the practical implications of these reforms, and we'll examine how employers can prepare for and adapt to these changes. So, and I'm going to hand over now to Sheena Harris, our Senior HR Consultant at HR Solutions. Sheena works with a diverse range of clients, both small and large, and from various sectors. So I'd like to now hand over to Sheena. So welcome, Sheena.
Thank you, Victoria, and good morning, everyone. There's so much been covered already, so we'll just try to dissect that a little more now. So in terms of the reforms, we know that they're significant. We know that they're likely to lead to the biggest shake-up of employment law in years. If we can give you any reassurances, then we would say that the fact that most won't come into effect until next year means, as Victoria and Sue have just been saying, it isn't too late to start planning. And hopefully the seminar and the further webinars, seminars and future content that we share with you will give you plenty of ideas to think about for your own businesses. And we can see that there are a range of businesses on this seminar today. So what we want to do is discuss the reforms through the lens of an employer, and as myself, a consultant working with many businesses, in order to share thoughts on what they mean. Okay, so if we go to the next slide.
Yeah. Okay.
So what we're going to do is we're going to segregate everything into three main areas for you, and then we're going to focus on those areas. So we're going to be looking at the costs, both direct and indirect, operational working practices, and also your business strategy. And we're going to be looking at them one by one. So starting with costs, as we've already said, these reforms will introduce significant direct costs, and we believe these will be primarily through your increased wage bills. This stems from adjustments to the national minimum wage. You've got the enhanced statutory payments and the introduction of new forms of paid leave. So businesses with substantial workforces earning at or near the minimum wage, especially those employing younger employees, may experience the most pronounced impact at this time. So what we believe that you'd need to do is implement comprehensive training for staff, all staff, including line managers, employees, HR, and your payroll teams. Because this investment is essentially critical for ensuring your compliance and preventing any enforcement from that Fair Work Agency, which does or will possess statutory powers to enforce these regulations and potentially impose penalties as well. The extended timeframe for workers to file tribunal claims also necessitates thorough understanding and adherence to that new legislation. So where we're still looking at costs, implementing the new leave provisions and revised statutory leave rules, such as the removal of waiting days, updated SSP calculation processes, this will all likely require system upgrades and potential adjustments. And then beyond your direct financial outlays, employers really will need to account for the significant management time and effort required to prepare for the reforms when they're coming in. We can also see that the increased wage costs might necessitate business restructuring, perhaps in making redundancies. And Victoria referenced the changes to the collective consultation rules. So again, all of that would then require quite careful preparation just to make sure that everything is aligned with these reforms and to avoid the costly protective awards at any employment tribunals. So now just looking at the operational working practices. So when we think about this, the reforms will require you to make changes to how you operate essentially. So in looking at developing robust procedures for managing things like SSP reforms, that will be essential. As we've already said, those proposed changes to statutory sick pay SSP, particularly for low earners, will require quite a meticulous review and an overhaul of existing SSP management procedures. It will also require you to ensure payroll systems can accurately handle those new calculation methods, which will introduce an added complexity. And this then leads on to a focus on system updates and thorough staff training in respect of those elements. Then moving on to reforms around the consultation, it may also require adaptations to working practices. So the bill places a heightened emphasis on effective consultation, especially in areas like redundancy and changes to staff terms and conditions. So with that, there must be an established, clear, transparent consultation process, and that's to mitigate the risk of any disputes and legal challenges. So your documentation, which aligns with that and underpins that, will need to be robust with really clear channels of communication with your employees. Moving on to activities, I mean, we think it's really quite fundamental in preparing for the new and updated legislation with your handbooks and your policies and your contracts. Your existing documents will probably require quite quick, comprehensive review. We've got some time with some of those reforms for next year, but we just need to make sure that they are aligned to the new legal requirements. So this includes those changes to leave entitlements, flexible working, and the other key provisions. And as Sue and Victoria were saying, there's new information coming in daily, so obviously we'll keep you updated. So just making sure that your documents are compliant is paramount. And then consideration must also be given to the requirement for new or updated systems and working practices. So the introduction of the new leave entitlements and changes to existing ones will likely require the implementation of new HR and payroll systems or significant updates to the existing ones. So there needs to be more flexibility essentially, and perhaps changing employee expectations on that. And that leads into the training of the workforce, which will be critical. So comprehensive training is essential for all levels of staff, and all stakeholders must be fully conversant really with the new legislation to ensure that compliance on all sides. And then when we're looking at increased absence, I mean, obviously with the changes to the SSP and the removal of the waiting days, that's certainly something that could bring about an increase in absenteeism as a result of the increased employee awareness of that right. So employers will need to develop robust absence management procedures to minimise any disruptions that could cause. And then further resource planning and additional cover would link with that. So anticipating increased absence and adapting to those flexible working patterns. So you may want to consider any additional covers to maintain your operational continuity. With all of these developments and complexities of some of them, along with raising your employee awareness, there could then be the potential of any disputes. So the complexities of this new legislation and the potential for misinterpretation could lead to employee disputes at times. So it's really important that there should be a focus, as we've already said, and will continue to say, on the clear communications, the transparent processes, and as early as possible dispute resolutions. We might, with some of the reforms, also expect to see some elongated processes. So, for example, the increased consultation requirements with the removal of the one establishment and more complex procedures may lead to slightly elongated HR processes. So it's really just a case of considering how to streamline them where possible to minimise any delays. And obviously, we've already talked about that reform to industrial relations, where there could be an increase in trade union recognition. And that's where the bills are strengthening the power of trade unions. So it's again a case of just being prepared to engage with trade unions in a constructive and collaborative manner where possible. It's quite a big slide. So I'm going on to the business strategy, which is the third sort of operational area. So what we want to say is that, we know that this employment rights bill is a significant shift in the UK's employment landscape, and it does extend far beyond simple policy adjustments. So, there will be a wave of financial and strategic implications that will reshape operations. We need to consider budgeting and forecasting challenges. So those reforms to the national minimum wage, enhanced statutory payments and new forms of paid leave will directly inflate the wage bills, and this will necessitate a fundamental reassessment of budgeting and forecasting models. And with the national minimum wage being linked to the cost of living, this will introduce a layer of unpredictability, so making long-term wage bill projections a little more challenging. So there will need to be an adoption of more agile and responsive forecasting techniques. This could all also lead to an impact on competitiveness. So the cumulative effect of increased wage costs and potential administrative burdens and the potential legal challenges it will raise operational costs perhaps. So businesses, they need to adapt efficiently, and those that fail might find themselves at a competitive disadvantage compared to those that may embrace the reforms more proactively. And we might also see an increase in need for potential business restructuring, which we've mentioned previously. So with those increased wage costs, it may force businesses to consider restructuring operations to reduce the overheads, if you like. And we also have changes to those collective consultation rules, as we've said, with the removal of the one establishment. So these increased financial pressures may lead to redundancies and therefore require that careful planning to mitigate any legal risks around that. And it might also be that you might want to consider restructuring to improve your efficiencies or utilising technologies perhaps as well. Consideration also needs to be given to any pressure on pay differentials. So obviously with the increases, again, we're talking about the national minimum wage quite a lot, and that could narrow pay gaps. So it may compress pay differentials, which could lead to dissatisfaction amongst higher paid employees. So could lead on perhaps to retention challenges, as skilled employees might want to seek opportunities elsewhere. So again, it's reviewing and adjusting any pay structures to maintain fair and equitable compensation. So regarding employee engagement and retention, you will need to really consider how the reforms are implemented. If they're implemented effectively, they may enhance employee rights, improve job security, and boost engagement. But if they're not managed effectively or poorly managed, they might just lead to increased administrative burdens and frustration on the part of employees. And where the slide references ability to attract top talent, businesses that demonstrate a commitment to fair employment practices and well-being for employees will gain a reputational advantage and making them more attractive to top talent. So businesses really, to attract and retain top talent, will need to offer competitive benefits packages that reflect those new legal requirements and employee expectations. And as we probably know, a company culture that's seen to be fair and inclusive and transparent will attract the best employees. So really, strategic planning, including the development of a strategic people plan, is going to be imperative. This is why we're doing this seminar, because businesses really do need to be planning for these changes as soon as possible, conducting thorough impact assessments, developing robust implementation strategies, and perhaps investing in HR and payroll systems and training to ensure compliance and effective management of those reforms. So transparent, consistent communication with employees is essential for building that trust and minimising any anxieties with these reforms. And you may want to review your financial models as well, taking into account the changes that this bill will cause. So this all needs very, very careful and considered planning, and therefore we advise that you review your business strategy. If you don't already have a strategic people plan, then obviously you can start looking into that as well and developing it as soon as possible. So there's a lot that we're going through, and we appreciate that you may be feeling a little overwhelmed, but we can review the next action steps. So what we would like to do is just take some time to provide some guidance on how you can help your business prepare for those changes ahead. And this slide sets out 10 main areas that we believe are important. So we can't emphasize enough how crucial proactive planning and early prep will be, as well as seeking expert advice, and if you're in doubt or unsure, then to do so, to make sure that you're not misinterpreting any of the reforms. So we believe that you should stay informed and understand the reforms. There are significant changes being introduced covering the whole employment life cycle. So therefore, there will likely be few areas left untouched by the reforms. Carry out a comprehensive impact assessment to understand how each of the reforms will impact your business. So evaluate how each reform affects your business operations. And for instance, the removal of the qualifying period for unfair dismissal may require revisiting your onboarding and probationary procedures, for instance. Third one, in considering your budgets and forecasting. So we talked about the changes to the national minimum wage and enhanced sick pay provisions, as well as the other forms of paid leave. So this will all require a revisitation of your budgets. And then number 4, review your employee value proposition and how you can remain a competitive employer. So you could reevaluate any benefits packages, offering career development opportunities, promotion of positive work-life balances. It's all just a case of reviewing those areas as well. Then we're looking at carrying out a workplace audit of your current working practices, and any gaps should be factored into your planning. And ultimately in bridging those gaps and ensuring compliance with new regulations. The next one is developing compliant policies and working practices. So, making sure your policies are updated to align with the new legal framework. And then engaging and consulting with your workforce. So, just making sure that you're fostering open communications by informing employees about upcoming changes, perhaps seeking input on policy development. And then reviewing existing relations with any trade unions. So, we've already said that these reforms aim to strengthen trade union rights. So evaluating your existing relationships and or preparing for increased union engagement. And then training your workforce, your line managers, your employees, your HR and your payroll teams. And this training will ensure understanding and compliance across the business. And then developing a strategic HR plan. So creating a proactive HR strategy that aligns with the new legal landscape that we find ourselves in and support your business objectives at the same time. So before handing back to Victoria, it is quite prudent to share insightful statistics, which can help to put what has been covered thus far into some context for you. And this relates to the latest tribunal statistics. So you'll see a table here, which is based on data published in the latest Employment Tribunal Award statistics and provides us with a good reminder of the importance in having effective and legally compliant HR practices. So you'll see that the maximum award paid for sex discrimination on the table there was £995,128, which can give you an idea of the worst case scenario. However, more realistic and typical amounts paid are detailed in the average column on the screen. So hopefully that just gives you a bit of a flavour. I won't go through every single one, but it just gives you a bit of a flavour of why we do what we do. There are reasons for adhering to the legislation and complying and having those processes in place. So, cover quite a lot there. Now would be a really good time to hear from you and for everyone to get a feel for how others are feeling around those reforms. So, Sue, if we could go to the next poll, if that's possible, please.
Just launch that. There you go.
Yeah. What do you feel is the biggest concern to your business when it comes to the reforms? So, if you could please respond.
Okay, just give that a few more seconds. Okay, I will close that poll and share those results. There we go. So pretty evenly split with the top three, isn't it?
Yeah.
The increased costs and admin burden, as well as, on all the uncertainty we all have about the details of the bill. There's lots of questions coming in from you. Quite a few of them are we just can't answer at the moment, but everybody I can see is concerned about the detail because it's all in the detail, isn't it? Especially around the sort of, how long is the probation period? What's the interaction between that and the unfair dismissal? Day one right, and there's such a huge impact on that we're all needing to know more and how they're going to enforce that as well.
It's so far-reaching, isn't it? And I think just emphasising Sheena's point a moment ago about the need to staying informed and just staying up to date, because it's just a beast of a bill, isn't it? But yeah, we share those concerns as well.
Absolutely, yeah.
And I think the smaller the business, the bigger the impact is going to be, because especially around the sort of administrative burden and the increased wage costs, because that's huge. You very often haven't got an HR department or even an HR person to help with all of this, and so you're managing it within the team. It could be a very small team, but there's everybody's going to have to comply with the majority of these reforms. So yeah, it's definitely going to keep us busy.
Yeah. So we've got a second poll as well for everybody.
Yeah, which is, which
So
of these reforms are going to be the biggest impact on your business? I think we won't be surprised by these results coming through. I will just close that and share those results. Yeah.
Sick pay.
Managing absences is going to be, it always has been the biggest number of queries we get through our helpline and through the teams. It's always around managing absence. And yeah, I can only see that increasing with these changes.
Yeah. And going back again to one of Sheena's points around, you know, review your existing absence management procedures, you know, see how you can make it more robust, or it's going to be key. You know, and just your tools like your return to work interviews, you know, they're fundamental for deterring, for a deterrent for taking absences.
Well, this is it, because as we've said, you know, by removing those waiting days, it could lend to higher absenteeism. So I'm sure that's a worry for many employers. So it's making sure that the processes around managing absence are as robust as possible. As you said, Victoria, to deter the non-genuine absences.
Yeah. Okay, I think we've got another poll.
Okay, yep, we have. So I'll hide that and I will share the next one. So this is, which of the following potential challenges do you think you could face when implementing these reforms? Just looking at the questions coming through as well. One of the biggest impacts, they think, is the probationary period. I guess that's linked in with the sort of the costs and the day one rights, and it's kind of all the whole piece, isn't it? But yes, absolutely, it is one of the biggest impacts.
Yeah, and
as well.
Whilst we've got the obvious direct costs that Sheena's gone through, you know, it's all the indirect costs, the management time in managing the processes, learning the processes through training. Yeah, it's definitely has significant budgeting implications.
So there we go. There's those results. So pretty equally, the budgeting and the ensuring compliance, but communication as well is going to be key, isn't it, to ensure that's clear, and it's clear that it's based on the legal requirements. It's not just the company being more stringent or strict on the on the rules and regulations around managing staff.
And I guess on the giving some reassurance to everyone here about maintaining compliance. I don't know if anybody knows, but we offer, there's an audit that you can carry out, and we'll be developing that even further. So as we know the detail, when we get nearer to commencement date of the reforms, our HR audit that you can currently use will obviously be expanded and will reflect the changes, and that will be an essential tool for everybody to help ensure that they're compliant. So look out for when we develop that.
Absolutely. So, there's one more, I think. Have we got at this point?
I think this is probably a good opportunity to take some of those questions on the bill. If we've had, like what you said, we've had plenty. So
yeah, we have.
Fire away then.
Well, if we stick with the ones, the biggest number of questions that have been around is the the day one rights for probation periods, the implications on probation periods, what that'll look like in employee contracts, and you know, the unfair dismissal as well. So there's lots and lots of commentary and question around that, and the it's kind of what everybody wants to know is how soon will we need the detail, and which is obviously key, but we know it's coming in, don't we? So it's just literally all we're waiting for is the detail. I don't think they're going to change. I don't think we're going to not have that change. I think it's just how they're going to implement it is what we're waiting on.
Yeah, exactly, because the reforms, so the Parliament is making amendments. Some are being accepted, some aren't, but essentially the reforms that were set out back in October are pretty much there still. So it is, what does it mean in practice? What is the detail? What length will the probation period be?
And we know they're considering 9 months, but they are looking at all the consultation. So, you know, there's a lot of commentary that they're taking into account. So there will be some modifications following that commentary, that consultation. And that's what we're now waiting. You know, they are currently working through it all. They've provided an initial response, haven't they, to some of it, and we're just waiting for more and more detail to come through. And I think that's also linked with other questions around when is it coming into effect, the 2-year rule, the removal of that, and the implication of that on short service dismissals. Will we still be able to do it? You know, we know it won't be before autumn 26, but we do need to consider the impact and how we manage the 2-year process sort of now, and just consider in that context how we might need to change. So, but yeah, a lot of it we'll wait. We're waiting on the detail, aren't we? And that's why we think that's one of the biggest changes and the biggest implications.
And I wouldn't be surprised if we end this seminar and we see lots of updates having taken place while we've been talking.
Absolutely.
We've seen a lot of responses this week so far on some of the consultations. So it'll be interesting. But I think definitely this year is about preparing. Examine what you currently do. You've got a high level overview of what's changing, and therefore you can to some extent do some planning and understand which policies will need looking at, which working practices need looking at. So start the planning, like Sheena said as well.
And I guess some of the questions are around, do you know how much notice will be given of these changes? All we know is we'll be given notice, but I think they'll vary, won't they, depending on whether they need legislation or not. So some of them they can implement in fairly short notice, can't they? Because the legislation's already there. They're just adapting that, and it won't take much more to bring it in. But some of them will. We know they'll be notifying us that it'll be from next year, and they will hopefully give us a bit more notice, some of the bigger ones, because they'll have to take into consideration processes that are already being worked through, and therefore that employers will need time to actually make the switch. But that's why thinking about what you do now and what might need to change, if you've done that bit, when we do get the notification, then at least you've done your review and your assessment of where you are and know actually what needs amending and changing, so you can implement it fairly quickly. So good. So the other questions around the sexual harassment changes. So one is around the reasonable steps. Quite a few questions around reasonable, and I think they have confirmed they're going to define reasonable better, or is that just one of the consultation requests?
Yeah, we don't like the word reasonable, do we?
No, not in HR.
It's down to each and every case to determine what is reasonable, so it's not always straightforward. So it is hard because you've got to show an evidence, you've exhausted every possible option. That's you taking all reasonable steps. Oh, so it is very much fact specific, isn't it, Sue? I think on the case.
It is, but as I know in the consultation on the wider bill,
Yeah.
there has been some calls for the government to consider defining reasonable in some of the areas. Whether it's on this particular section, I'm not sure, but definitely there is a call for defining reasonable. So we may or may not get guidance. We may or may not get guidance on the harassment area, but we may on other areas. So again, it has been highlighted, and the other areas around training. Do you think we've been asked? Do you think employers need to be training all staff levels on harassment to ensure compliance? Well, yes, absolutely. That's the most important way you probably can demonstrate that you fulfilled your duty to take reasonable steps in preventing it. So. And I think this reasonable steps is reasonable. It's one of the ways you can say, well, that's a reasonable step is to make sure staff are aware and not just deliver them a sort of remote piece of training in sort of 10-15 minutes. It's actually a proper training that allows interaction and allows discussion, and that ensures that your employees actually do fully understand the implications, and that there are areas people they can contact to discuss it further if they're not sure or if they're concerned. But yeah, it's one of those reasonable steps. And finally, we have lots of questions again, as you might expect, around calculating annual leave. The good news for everybody is that we're running a webinar next week on calculating just that, and there are thousands that have already signed up to it. So, yes, I think watch that or watch the recording of that. Sign up for it, because we'll go into that in detail.
Exactly, it's one of our favourite topics.
Yeah, we do get lots of questions around
Come
that.
prepared with your caffeine, a cup of coffee or a cup of tea.
Yes, you'll need it. So yeah, I think that's probably all the time we should do now, and I'll continue to collate all the questions, and we'll have another session later.
Brilliant. Yeah, thank you. So let me now move on to talk about the neonatal leave that's coming in as of the 6th of April, so not far away. And I would say right from the outset, for those of you that remember the implementation of the shared parental leave, it has similarities to that, let's just say. So I'll come on to that in a moment. So there will be new entitlement for babies born on or after the 6th of April, and that is for the employee to have up to 12 weeks paid leave. The leave must be taken in blocks of a week. The entitlement to leave is from day one of employment, but the entitlement to statutory neonatal care pay will be based on a qualifying period, and it will be paid at the same rate as other forms of statutory family leave. So as you can see here in this grey shaded box, the entitlement to pay means that the employee must have at least 26 weeks of continuous service at the 15th week before the expected week of birth. And then in the case of adoptions, the week immediately before the neonatal care starts for the adopted baby. So when it comes to implementation of the regulations, they will apply in England, Scotland and Wales, not in Northern Ireland. Whether that comes in later, we shall see, and I would probably expect it will. But at the moment, on the 6th of April, it's only if you've got offices, premises operating in England, Scotland and Wales. Now, the entitlement applies to the parent via surrogacy, the partner of the mother, and who has responsibility for the baby's upbringing. And the baby must need 7 days or more of continuous neonatal care that begins within the 28 days of their birth. So again, if we look to the right hand side here, there's a legal definition as to what neonatal care is to mean. So neonatal care will mean any medical care that's required in the hospital, any medical care required on leaving that hospital where they received that neonatal care, medical care from a consultant, including ongoing monitoring and visits to the baby from healthcare professionals as has arranged by the hospital where they received that neonatal care, and of course also for palliative or end-of-life care. Now the rules, this is why I said earlier around, if you remember the shared parental leave coming in to force, there are, we would say, complicated or complex rules around it, which I will come on to. So first of all, there's going to be rules in place for when there's multiple babies that are born of the same pregnancy. Employees are remaining entitled to their same terms and conditions of employment, except for pay. So that's just the same as in other forms of family leave. Employees will be protected from suffering a detriment or for being dismissed for exercising their right to take neonatal leave and pay. And when there's been a dismissal connected with them taking the leave, that will be automatic. Now, this is where it gets complicated. There's going to be a two-tier system for managing the rules around taking leave, managing leave, and pay. So as you can see here to the right, there'll be tier 1 and tier 2. Now, it's really important when managing a period of neonatal leave to understand which tier the employee is falling in, because depending on the tier will determine how a week can be used. Again, it will also determine the amount of notice required when requesting leave and when requesting pay. And also, depending on the tier, will determine how neonatal care leave operates when there's other statutory family leave entitlements. Now, as I said, it's complex. We're going to be publishing our updated family leave policy in the coming weeks, which will set out all the guidance and the rules, and will accompany that with checklists and various guidance. So do get in touch with us if that's something that would be of help to you. I guess from our perspective in terms of thinking about next steps, first of all, consider, do you want to enhance the statutory entitlement? If you do, just consider how that operates in line with all family leave entitlements, because you don't want to inadvertently discriminate. But if you already are enhancing your pay and benefits, then consider how enhanced statutory entitlement would look in the case of taking neonatal care leave. You need to think about establishing clear processes for employees to apply for the leave and claim their entitlement to pay. So as I said, with this whole tier 1 and 2 system, it can become complicated, and it's about making it as easy as possible for the employee at a time that's going to be particularly stressful for them to know the simplest way of doing things. So try and establish and think over the next few weeks what clear process and documents you're going to want your employees to complete. Obviously, there'll be a need to review and update your existing handbook, company policies and contracts of employment. So as I said, do let us know if you want our help in any of that. And of course, how will your payroll and HR records need to be amended and your systems updated to be able to process the leave and any pay requests? So just think now over the next few weeks about the implications for that. But given the nature of the leave, consider actually, if you don't already offer any employee assistance program, actually from an employee engagement perspective and as part of your employee value proposition in terms of showing that you take the welfare of your employees with care, consider actually, does this present an opportunity for you to look at introducing an employee assistance program? Because somebody that's needing to take time off for neonatal care obviously it's going to be, like I said a moment ago, extremely stressful, and having that access of support for them will just help ease that in some way. And then vitally important is your line management training, and also training for your HR and payroll teams, just in terms of understanding notice requirements, how leave can be managed, how you manage tier 1 and tier 2, etc. So I just want to do a quick pulse check, and that really is literally to know, do you feel prepared for the new neonatal care leave and pay? And again, this is about just seeing how you all feel, and hopefully it could give you some reassurances to know either you're not on your own, other people are feeling the same.
It's definitely been our hot topic, hasn't it, over the last
It has.
week? As we're trying to understand it all. I think we need a whole session on this.
Definitely, and that is definitely something, a webinar we can run in the coming weeks, months.
Okay, I'll close that and share those results.
Okay, so that's just to let you know that you're not on your own. Thank you.
There you
So
go.
now we're going to be discussing developments in health and safety law. And so I'm pleased to be able to introduce you to Lauren Gibson. So Lauren is our health and safety consultant who's going to be discussing Martin's Law. So welcome, Lauren.
Thank you, Victoria, and good morning, everyone. You will be, I'm sure, relieved to know that the world of health and safety legislation moves much slower than that of employment law.
Yes.
So I only have one thing to talk to you about today, and that is the pending Terrorism Protection and Premises Bill. So this is developed in response to increasing threats of terrorism and the urgent need to enhance public safety. And the bill is also to be known as Martin's Law, which is much easier to remember. It's named in honour of Martin Hetz, who was a victim of the 2017 Manchester Arena attack. And this legislation will require persons with control of certain premises or events to take steps to reduce the vulnerability of the premises and its occupants from acts of terrorism. After a quick check this morning, the bill is now at its third reading in the House of Lords and is expected to receive royal assent in spring 2025, so very shortly. We don't envisage that anything will drastically derail this, as both the current and former government were in unanimous support for the bill itself. What we do know at this stage is that the Security Industry Authority, the SIA, has been chosen as the regulator, and we expect that following the royal assent, duty holders may have between 1 to 2 years to implement the changes necessary to comply with the legislation. So there is a little bit of breathing space for us there. Though I must say it is important to start preparing for these changes now and not to kick them down the road. The regulator, the SIA, will be responsible for setting out clear expectations as to what is reasonably practicable, that word again, reasonable, and what compliance with the legislation looks like. Under the proposed legislation, you will become a duty holder if you are responsible for a venue or you host an event with over 200 attendees. And I will go on to talk about the types of organisations that will and will not be affected in the next slide. So as not to overburden the industry with unreasonable costs, the bill is to be implemented as a two-tier system. Firstly, it's important to stress that there will be no duties for venues or events with a capacity under 200 people. The standard tier then will cover venues and events with a capacity between 200 and 799 people, and the enhanced tier will cover those over an 800 cap. For smaller venues falling within the standard tier, the legislation focuses on having appropriate procedures in place in the event of an attack, and there should be no expectation to implement costly measures in the standard tier. Venues and events with a capacity of over 800 or more, so things like stadiums and arenas and really large venues, will have more stringent security requirements which may come at a cost. Therefore, it is important to start thinking and budgeting for these now. Rather than all starting to panic and count on your fingers and toes the capacity of any venue or event you plan on hosting, you should be able to revert back to either your licensing application or a fire risk assessment for the max capacity, and you will be able to use this as a guide. So the types of venues that will fall within the scope of the legislation, as you can see listed there, are leisure parks, piers, zoos, shopping centres, cinemas, museums, and it will also impose duties on premises such as places of worship and educational premises, though these come with a caveat. So, educational premises such as childcare, primary, secondary or further education that can be expected to host 200 people or more at the same time will fall within the standard tier regardless of their maximum numbers. Higher education, however, is an exception to this rule due to the open nature and access by the members of the public. Then this can itself fall into the enhanced tier. So this is looking at things like university campuses. Similar to education, all places of worship that can be expected to host 200 or more individuals will always again fall into that standard tier. So no need to implement the controls of the enhanced tier if it's a place of worship. Premises that are excluded from the bill, parliamentary buildings, which I always find quite interesting, so they've ruled themselves out of having to comply with that one. Then we have non-ticketed parks, gardens and recreational grounds and sports grounds. So for example, Hyde Park during normal operational hours will not fall within the scope of the legislation. However, if Kylie Minogue decides to have a concert there and it's a ticketed event, then this will then fall within the scope of the legislation. And then another exception to the rule is transport premises, so underground stations, airports, rail, those sorts of things. And the reason for that is because they already have robust security measures in place. So what does this legislation translate to in practice? So if you feel now that you are going to be a duty holder, what does that practically mean for you? So as I've said previously, the standard tier is designed not to be costly and overburdensome, but there are some things that you will need to prepare for. The anticipated duties involve notifying the regulator that you own a premises that falls within this capacity. So that will be at some point reaching out to the SIA and registering yourself as one of those venues. You will also be expected to develop a public protection policy, which should outline your internal procedures for managing, and then also go on to develop risk assessments and operating procedures as well. The implementation of such will require a level of staff training and familiarisation with the up and coming legislation. And then we can look at implementing other practical measures such as undertaking drills to support and supplement that staff training so that people are aware of what to do in an event or an act of terrorism. Also looking at developing crisis management plans and also looking at things like first aid in particular. The enhanced tier then will include all of the above. But what it will mean is that you have to provide the regulator, the SIA, with a copy of those policies, procedures and risk assessments. Not sure how that's going to work at the moment, but it seems to me that there will be an element that they will need to review those documents, potentially approve them, or certainly provide feedback on them. You will also be expected to appoint a designated individual, who will be ultimately responsible. And in this tier in particular, you may, following risk assessment, and need to implement enhanced physical measures in those premises. So that might include things like increased surveillance, increasing any security teams that you may have, using technology such as facial recognition and CCTV, and just generally increasing your security presence. could also mean implementing structural changes to the venue, such as bollards or reinforced barriers. Improved signage, so directional signage, what to do in the event of an emergency. So if you think that these venues are open to members of the public, how will the public know what to do and how to act in those situations? And again, looking at emergency first aid training, in particular things like specific training on catastrophic bleeding could be vital in these situations. So I think we've got a poll next. Perfect. So it's safe to say that we'll all encounter the effects and benefits of Martin's Law, certainly in our personal lives in years to come when we enter a music venue or head to the cinema. But we'd like to know, do you think Martin's Law will have a direct effect on your organisation?
So that poll has launched. We'll just let that run a minute. There's quite a few people asking about the who's caught by this law, Lauren. Things like, if you host an event at a hall, is it the venue's responsibility or the organisers?
Yes, it's tricky. It's a bit of a grey area at the moment, and I do plan on going on to talk about that in a second. But health safety legislation, a duty to cooperate and coordinate. So it could be that there's some shared responsibility there, certainly. And I would encourage any business to do its due diligence and ask venues, if they are hiring them, what measures they have in place, and certainly ask those questions and challenge them on that as well.
Okay, thank you. I'll just close that and share those results. There we go.
Okay, yeah. Unsure. And what about workplace social events? So like, I'm thinking Christmas parties, and you go to a external venue that would fall in scope.
Yeah, so for those that are unsure or don't expect that the legislation will have a direct on them, I would encourage you to think about events that occur outside of your normal day-to-day operation. So for example, Christmas parties, family fun days, award ceremonies, trade shows, those sorts of things, because you may find then that they meet the threshold of the legislation.
Right. Okay, interesting. Thank you.
No problem.
Okay, thank you. I'll hide that. Back over to you.
Okay.
Thank you. So yeah, as Sue just briefly touched on there, if you are hosting these one-off events, it doesn't matter if it's not your bread and butter, it's not your day-to-day business activity. If it does meet that threshold of being over 200 people, then you will be expected to comply. When it comes to hiring a venue, if you are hiring a venue and you're hiring all the staff and somebody else is managing that element for you, such as an events organizer, then at this point, we would say that there's potential for a shared duty, but more so leaning on the host themselves. But either way, as a business, you should exercise your due diligence there and making sure that those measures are in place. I'm not surprised to see that so many people on the poll didn't feel that the legislation was necessarily relevant to their organisation as well, as it is quite niche and generally only covers large-scale events with a specific focus on terrorism. However, the Southport stabbings and the subsequent summer riots that followed are a good example of a situation where they may not have fallen within the scope of this legislation, but we all witnessed, some of us firsthand, the impacts that this had on individuals, communities and businesses. Morally, we should be asking ourselves as a society and as business leaders, what more can we do in these situations to prevent such devastation? So whether your organisation falls within the scope of this new legislation or not, this is a great opportunity to look at the wider risks to your employees and your organisation from wider external threats and consider how you would deal with these effectively whilst maintaining business continuity. Some examples of external threats to business include things like antisocial behaviour, violent altercations, property damage, and the impacts of protests and demonstrations. All of these examples can have effects on the health, safety, and well-being of staff. They can result in absenteeism, result also in business disruption, and can potentially generate bad publicity for your organisation. The wider question we should be asking ourselves is, are these external threats reasonably foreseeable? And what can we do to mitigate the impacts of these? So what I would suggest is, like I said, it is a little bit of a grey area. People are still a little bit of unsure. We are waiting for, obviously, the bill to receive royal assent, and we're hoping that the regulator, the SIA, will develop some either guidance or approved codes of practice, practically guiding us on how this will be implemented in much finer details. But if you have any questions in regard to this area, then please share your questions with us, and hopefully we can answer some more of them at the end. In the meantime, I will hand over to Victoria.
Thank you, Lauren. Thank you. That's really been quite interesting and helpful update. As you said, we don't often get many health and safety updates, do we? It's more the HR ones.
Fortunately.
So it's really helpful. Thank you. And quite often we see the development of new law because of something that's happened in our society, and as that last section has sort of indicated. And for employers, we need to also consider how the outcome of case rulings can also have implications for how organisations move forward. So I'm just conscious of time as well. We've still got a good 20 minutes scheduled. So in this next section, I've got 3 cases I just want to share with you. All of them are significant and have practical implications. And we're going to start with the Higgs v Farmers School. The judgment came out actually at the start of last month. And this is a case where Mrs. Higgs was employed by the school. She'd been dismissed back in 2018 because she had made some personal Facebook posts in which she was sharing her expressed her gender critical beliefs about LGBTQ plus relationship education in primary schools. Now, the school deemed her Facebook posts, which were on her personal account, potentially homophobic and transphobic. That's why they dismissed her. She took the claim to tribunal. The tribunal ruled that there had been a fair dismissal because her posts could reasonably lead to the perception of homophobia and transphobia, and there was that connection with the workplace. Now, she appealed that decision and took it to the Employment Appeal Tribunal, who overturned the original ruling, saying that actually a proportionality assessment of the dismissal was required. The EAT deemed the dismissal to be an act of direct discrimination, and it set out as part of its ruling a list of factors to consider when assessing proportionality. Now, the case then progressed to the Court of Appeal, which also agreed with the Employment Appeals Tribunal that her dismissal had been direct discrimination. And I want to share with you on this slide why that was. First of all, the language of the reposts were not grossly offensive. The language was not the claimant's own, except for her repetition of using some words from the original post. The disciplinary panel accepted that there was no evidence that the reputation of the school had been damaged. So instead, the school's concern was about potential damage in the future for the school. They also considered the fact that the risk of widespread circulation was speculative at best, because the posts were made on the claimant's personal Facebook account in her maiden name and had no reference to the school. Now, by the time of the disciplinary hearing, which had taken place several weeks after the posts were made, only one person was known to have recognised who she was. So even if readers of the posts might fear that she would let her views influence her work in the school, neither the disciplinary panel nor the tribunal believed she would do so. And so there was no reason either to doubt her assertion that about basically that she wouldn't bring this into school, that she would never treat gay pupils or transgender pupils differently. She had no complaints about any aspect of her work for over 6 years, and despite it being unwise for Mrs. Higgs to have reposted the material that had used provocative language, and it had the potential to link with the school, ultimately the Court of Appeal could not say that her dismissal was justified. Now, the consideration for employers is around, it is a very difficult question of where to draw the line when considering disciplinary action and whether it would be lawful or not, when we're looking at the manifestation of an employee's belief, when it may be objectionable by others. Now, the courts were critical of her actions, and the Court of Appeal had agreed that the school had a right to investigate. But what we don't know from this case is whether a disciplinary warning would have been lawful, or the potential repercussions if she'd posted offensive content after having received a warning. This particular case was looking at the dismissal itself. So whilst actually on the one hand it's saying they were right to investigate, they haven't given a view on what would have happened had she been given a final written warning, say. So that's just an area to think about. Now, we have a handout to accompany this slide, and it uses the test that a tribunal will consider when for when an employer should carry out a proportionality assessment. Is the action of a dismissal proportionate in the circumstances? So please do take a look at that handout after the event. Now, the next case is Women Scotland versus the Scottish ministers, the Scottish government. And this is a high profile case. And it was a case that went to the Supreme Court back in November, and we're currently waiting an adjournment and for the judge's review of the evidence. It's a case in which the Supreme Court is seeking to determine the definition of a woman, because we have two pieces of legislation that give two different positions. And so this Supreme Court is trying to determine how these two pieces of legislation operate with each other. So the court is going to consider the legality of how the Gender Recognition Act of 2004 operates alongside the Equality Act of 2010. Two very different pieces of legislation, but important pieces of legislation. So the judge's ruling in this case will be determining how someone who is transgender should be legally treated in the workplace, amongst other environments, but particularly in the workplace, and to determine what the process of gender recognition means. And therefore, it's going to provide organisations with the legal standing position of, what happens with single-sex spaces ultimately. So the Gender Recognition Act states that if the acquired gender is the male gender, then the person's sex becomes that of a man. And if it is the female gender, the person's sex becomes that of a woman. However, when the Equality Act of 2010 refers to sex, it's unclear if this is meant to mean biological sex or legal certified sex as qualified by the Gender Recognition Act. And there we go, there's the slide, sorry, that I've moved on. So that's where the difference is. So the outcome really is going to give us a steer as to whether we have single sex spaces. So back in 2019, there had been a new act of law that had been passed, the aim of which was to appoint more women onto public sector boards. And in that legislation, it defines a woman to include people living as a woman who are either currently or proposing to undergo the gender reassignment process. and subsequently new guidance was published alongside it. Now, from the Scottish Government's perspective, in the guidance, it stated that the law would include women as defined by the Equality Act and by the Gender Recognition Act, and therefore a full gender certificate could be taken as declaration of someone's sex for all purposes. This is like for all legal purposes. And the Scottish courts ruled in 2022 that the definition of sex was not limited to biological or birth sex, but included those in possession of a gender recognition certificate. So, whereas the Scottish Government believed these two pieces of legislation are clear in their language, and what the legislation was taken to mean, the Gender Recognition Act makes clear that a full gender certificate applies for all purposes, and therefore a person who becomes a sex of their acquired gender is entitled to the protections of that sex, including protection against unfavourable treatment. And that's what the importance of this case is. It's the legal standing position on the extent of legal protections somebody would be given. Now, Women for Scotland Limited challenged that position, and their argument is that the meaning of the words man and woman should be taken to mean in their common sense of the meaning of the words, because sex is unchallengeable and an immutable biological state. Now, that's as put forward in the case. So this definition of sex is necessary in order to protect the rights of women. So Women Scotland believe the Equality Act supersedes the Gender Recognition Act, and therefore the definition of woman must strictly refer to the biological sex. So this is the difference in the positions that they're taking in their arguments. For Women Scotland, by the interpretation of woman to refer strictly to biological sex, it would mean employers would need to maintain separate legal treatment for those with a gender recognition certificate versus those whose sex is defined by biology. And therefore, if Women Scotland were to win the case, it would potentially limit the access of transgender women to women-only spaces, and potentially limit the access of transgender women to protections under the Equality Act. Now, if the Supreme Court sides with the Scottish Government, the implications for employers is that they will need to treat individuals with gender recognition certificates as women in all legal contexts and for all purposes, including workplace protections against discrimination. And therefore, the implications for employers is it could impact recruitment, gender equality policies, by potentially requiring employers to adjust their practices to accommodate transgender employees in single-sex spaces according to their gender identity. Now, that is a very complicated case. Appreciate it's a very sensitive area of the law, and it is complicated. I think it's just one to keep an eye out, because of the outcome of that case will have implications either way in which it has its finding. And then just our last case I wanted to share about, and this is about employment status between Mr. Bandy and others and Bolt Operations. Now, he was a private hire driver working for Bolt. Now, the claimants argued they were workers under the Employment Rights Act and also under the Working Time Regulations and the National Minimum Wage Act, and therefore entitled to certain protections and benefits. But Bolt contended that the drivers were actually independent contractors and not entitled to those provisions. Bolt argued that they were therefore independent contractors, not entitled to things under the Employment Rights Act, the Working Time Regs, and National Minimum Wage. And the case of Bandy v. Bolt, the tribunal ruled in favour of the claimants, determining that they were actually workers and entitled to the protections and benefits under those pieces of legislation that I've noted there. Now, this is significant for employers. Now, the reasoning behind the finding that they were indeed employees is because the control that Bolt had exercised over the drivers. The tribunal rejected Bolt's argument that it acted as an agent for the drivers because it found that Bolt operated a transportation business and that the drivers worked for Bolt, not the other way round. And they also found that under the principal model introduced back in August 22, the drivers continue to be workers, and the introduction of a Bolt link did not negate the requirement for personal service. When it came to working time, the tribunal determined that drivers were working when they had the Bolt app switched on, and therefore they were within their licensed area and were ready and willing to accept trips, provided they were not multi-apping. So the tribunal classed the drivers to be workers, and their work as unmeasured work under the National Minimum Wage Act. And then in terms of what this now means for employers, so there's real implications. It's really important to really understand the employment status of your employees. The control and dependency factors are crucial in determining this, as well as, you know, looking at your contractual terms. Ensure that your contractual terms reflect the true nature of the relationship that you have with your workers. And in terms of the control, a worker typically has less control over how, when and where they work. The employer dictates these aspects. Consider as well if there is that mutuality of obligation. What this means is where you are obliged to provide work and the worker is obliged to carry out that work, because where you've got that obligation, that then is another area leaning towards the situation of worker. Consider if the person can provide a replacement or whether they are the only one to perform the work. So again, depending on which way it is, will determine if they're more likely a worker or self-employed. So essentially, a self-employed worker should be able to provide a replacement. And then look at to what extent the worker is integrated into your business, which is why it's so important that not to integrate them into all the policies and the procedures and the working practices, because the more you do that, the more it blurs the lines and could give an argument towards them challenging their employment status, saying that they're workers. So we're moving on to other legal developments in terms of this year. Now, we've got another handout for you all. As is usually the case in April, we'll see an increase to the statutory rates. So on that handout, you'll see those. There are a few we're still awaiting for. Now, another area is the Data Use and Access Bill. It's currently going through Parliament. It was first put forward in the autumn and it's now already nearly at the end of its second phase going through the House of Commons. It started in the Lords, now it's nearly at the end of the Commons. And we can expect it to be passed this year. Although we don't expect the reforms to come into place until next year. I would think this topic again warrants its own webinar, because from a HR perspective, we do use personal data throughout the employment life cycle, and some of the reforms we're going to see relate to things like subject access requests, automated decision making in our processes and systems, and also how employers are to use AI and what kind of regulations we'll have. Moving on to the Domestic Abuse Safe Leave Bill, this was something that was put forward, and if it was to be passed, then it would give victims of domestic abuse a statutory entitlement of up to 10 days paid leave from work in each year. And that purpose of the leave is to ensure that they've got the support in dealing with the many challenges that can be experienced when trying to leave a relationship. It might be they need that time out to go and look for accommodation. It might be they need that time out to go and meet with their bank manager. You know, whatever the practical challenge, that is something that's being proposed in the Parliament at the moment, and is currently going through. And then finally, this is going to be relevant to all of you who employ more than 250, in that it's the Economic Crime and Corporate Transparency Act. It was passed back in 2023 and it's going to come into force on the 1st of September. And it applies to large employers, which means in their definition, it has to meet 2 or more of the following requirements: the turnover of 36 million, the total assets of over 18 million, or you have over 250 employees. And so from the 1st of September this year, where fraud is committed, large employers will be liable under a new corporate criminal offence of failure to prevent fraud, unless they can demonstrate that they had measures in place to prevent fraud by their employees or other associates. Excuse me. So this is good timing for me to get a drink and to move on to questions. And I am conscious that we've got 2 minutes of the scheduled time, although the system won't chuck us out. We can talk for however long we feel we can talk for. So if you are able to stay on a little bit longer, it'll be great to have you participate in questions. We're going to see what we can take, and we'll also obviously follow up with an FAQ after the session. So Sue, do we have?
We do. We have lots of questions, but the good news is a lot of them have been answered in subsequent slides, which is the good news. But also, what's lovely is that we've got so many around the health and safety update.
Oh, brilliant.
So, which is nice. So if I can just start, Lauren, a lot of it you have also clarified, but because there's lots of questions around who's going to be captured by this requirement and this duty in terms of hosting events, etc. So I think we've clarified most of that. Just 1 or 2 that maybe you might want to comment on. So we have a care home who holds coffee mornings fetes where general public can attend. Do they have obligations under the new Act?
Yeah, that's an interesting one, isn't it? Because I'm envisaging that, well, I don't know, but would they have over 200 members of the public on site at once at those events? And whether or not the existing residents in the care home would class within that 200. So that's actually quite an interesting one that maybe needs, maybe I need to go away and think about that a little bit more. Really, when it comes down to hosting the events as well, it comes down to whether they're ticketed or not. So whether you've got like expected numbers that you know are going to attend, rather than say sort of people coming and going and moving throughout the premises. Leave that one with me. I'm going to have a think about that actually, and we can answer that in the FAQ.
Absolutely, yes. It's just interesting to consider all these different options, isn't it?
There is certainly some grey area outside of that. Are you a venue, and are you, day-to-day people that host events? It's quite clear what they need to do, but on these sort of one-off occasions, as you mentioned, the guidance that's out there at the moment doesn't explicitly say. But like I said, this legislation is on the very cusp of receiving royal assent, so hopefully we will know more in the coming weeks.
Yeah, it's like everything, isn't it? We need the detail.
Yeah.
And one similar to that was outdoor arts taking place in a public area. I guess that's also a bit of a grey area, because
yes,
is it ticketed or is it free?
Yeah, exactly. So if it's a public area and you again, it's not ticketed, you're allowing people to come and go of their own free will, and it's a public space, then I imagine that wouldn't fall within the scope of the legislation. However, if you change that and you've got, say, somebody on a gate or an access point controlling who comes into that area, and you're meeting that 200 plus threshold, then that falls within the scope of the legislation.
Okay, and then a couple of just around the tier system and the implication of that on hotels, firstly.
I don't believe at this current moment in time that in terms of hotels being used obviously for overnight stays, that itself will fall within the legislation. But then if we look at hotels with halls, where you can hire the space out as a venue for a party, then again that could fall within the scope itself. But day-to-day operation of the hotel wouldn't necessarily fall within.
Okay, thank you. And then another one, completely different environment. It is a multi-academy trust who rents out the school halls, etc. Does that push them into the enhanced tier?
Yes. Well. So it depends on if that school hall has a capacity of over 800 people. If it's over 800 people, then that hall and how that hall is used will be the enhanced tier. If it's a cap between 200 and 799 people, then that would meet the standard tier.
Okay, thank you. And then something a little bit different. Do you happen to know if there are any changes coming to the regulatory reform fire safety order regarding competency of fire risk assessments? Just on a different subject.
It's a very interesting topic and one we discuss in the office all of the time. And like I've alluded to, health and safety legislation moves much slower than employment law. Yes, the industry as a whole is looking, following Grenfell, at competency of people working in the industry, but as of yet they haven't defined what that competency looks like. We as fire risk assessors ourselves are constantly monitoring the situation, because we want to make sure that, you know, we're doing the right things, we're attending the right training courses and have the correct qualifications. But at this moment in the time, we still don't know anything, unfortunately. But again, we are monitoring the situation and can keep you updated on that.
Thank you. And finally, do we know when Martin's Law is likely to be passed?
It's moving very quickly. So a couple of weeks ago, when I prepared for the slides, it was in its second reading. Yesterday it was somewhere else, and this morning it's third reading in the House of Lords. So we've been saying spring for a long time, but we're in spring now. So potentially April, maybe latest May. But like I said, we expect that there will be a period of maybe 12 to 24 months where businesses will have an opportunity to prepare themselves for the implementation of it. Okay,
thank you, Lauren. Just a quick HR one, and then I think we probably need to wrap up the questions now. But both of you and Victoria mentioned royal assent. Somebody's asked what that means. Is that the final stage, the absolute ratification before they announce it?
Yes. So essentially, it becomes an act of law. It's when it becomes legislation. So it's no longer a bill, it's an act of law. And then within the act of law, it will set out commencement date as to when it comes into effect. So sometimes it can have a date for the next day for it to come into force, or a date 3 months down the line, or 12 months time. But essentially, it's no longer a bill, it's effectively signed off and is an act.
Okay, thank you. So I think that's all for now. Thank you.
Okay, lovely. So let's move the slides on. And I mentioned ages ago now about auditing your workplace. So we do offer, it's a free tool to use, it's a HR risk audit, so you can sense check where you are now with the current legislation and where there's any gaps that we spoke about, didn't we, earlier, about it's now's a good time to do a sense check of where you are now. So that's the QR code there takes you to our free tool to understand if there are any gaps in your employment practices and from a compliance point of view. And we will be creating and evolving that risk audit as we get nearer to the implementation date of the reforms. For those of you that are regulars to our webinars, we have a schedule in place now. So for the rest of the year, Next week, Sue mentioned, we are running our webinar on calculating annual leave and entitlement. So if you employ irregular hours, part-year workers, employees who are part-time but with regular hours, or in any different kind of working arrangement, please do come along, because we're going to be talking about that topic. We're running a webinar around redundancy, prevention, the process and key steps for that smooth transition. That's going to be April, and we're going to be focusing specifically on sick pay changes in May. And we've talked quite a bit about the 0-hour contracts very early on in our seminar. We're going to focus in more detail in our webinar in June, at which point I'm hoping we'll have a little bit more clarity to go by. And then July is all about family-friendly leave and flexible working. So there's a QR code for you to access the schedule and to sign up. So it'd be great to have many of you there. And before we move on, we also want to run a couple of other polls here. And really, it's just to understand from you what further information or support you'd like to receive from us regarding what we've discussed today. It could be project support and assisting you in carrying out impact assessments, handbook development review, HR advice and support, training, payroll services, or, you know, on the back of Lauren's section about Martin's Law, you know, do you want us to get in touch with you about health and safety advice and services? So please do let us know. Keep that open for a bit longer, shall we? Lovely. Okay. And then I think that's okay. We've got a second one, which is more about our general services. Sue, I don't know whether you want to talk a little bit about that.
Sorry, yes, I realised I was talking on the previous one and I was on mute. So I was saying that we perhaps can consider arranging a separate webinar on the neonatal leave.
Yeah,
as
definitely.
It's quite complex and quite detailed. It's not something you can just do a couple of slides, do justice in a couple of slides. So if that's something you think you'd find interesting, then please do let us know. We welcome all the feedback. So if you would welcome a more detailed analysis of everything that's required as part of that, then do let us know. And its interaction with the other family leaves, because that also makes it even more complicated.
Yeah,
okay,
probably not for today.
No. So there you go. I'll pass back to you.
Yeah, thank you. Brilliant. And it's just, and I was going to say that we're also going to be looking, or I say we, Lauren is going to be launching some webinars in due course as well. So be sure to keep in touch and follow us with what developments Lauren will be sharing with us on her webinars. So let's move. So this is just to let you know that we offer a HR knowledge base. It's an online HR portal, and essentially it's our central place for content. So you'll have policy templates there, letters. You've got a bank of around 600 articles that cover the employee life cycle. So there's a lot of information there. So if you are interested in that portal, then please do scan that QR code to find out more and to get in touch. And of course, we do offer training courses in human resource management, employment, and of course, health and safety as well. So do let us know if you want to find out a little bit more of our training. And obviously, as we get nearer to the reforms implementation, I'm sure there'll be some training offered at that point as well. This slide is to let you know about essential safety. So Lauren's kindly shared her insights into the new law that's coming in, the Martin's Law. But also essential safety can offer support in terms of health and safety audits. They offer services around fire safety, CDM and construction, competent persons. They can offer online training, delegated training like I mentioned a moment ago, and provide advice and services in regards to food safety and manual handling. So do get in touch with us and Lauren in terms of further support that you need from a health and safety perspective. And this slide is just letting you know about the health and safety training that's offered that includes, Lauren, I don't know whether you want to talk through these. IOSH, Managing Safely?
Yes, so IOSH Managing Safely is a training course directed more at the managers, and then we also offer an IOSH accredited working safety, which is directed more at employees themselves. We offer manual handling training, fire warden training, and we also work closely with our clients and others to develop bespoke training packages that can be delivered internal to suit your business needs.
Brilliant, thank you. And really just to, before we bring it to a close, it's just letting you know how you can keep in touch with us. So you can get in touch by phone or email us at our inquiries mailbox. We are on LinkedIn, and of course you can get in contact with Essential Safety through their own mailbox and phone that's listed there. And then, as I said, you can follow us on LinkedIn. Definitely something worth doing in terms of keeping up to date with the reforms that are coming through. So really just want to thank you for everybody's attendance, participation, all the questions and poll responses. We really hope that you found this session informative and helpful and given you a lot of information to think about and some ideas on how to prepare. I want to obviously thank Lauren and Sheena for participating and sharing their insights into developments in health and safety and employment law, and Sue as well for sharing her insights. So please do get in touch if you've got any further questions, and copy of the slides, a link to the recording will be sent out afterwards, and we look forward to seeing you on our future virtual events. So thank you everybody.
Thank you, Victoria.
Thank you.